happens if you get arrested for domestic violence, the DA files charges against you, and the alleged victim wants the case dropped, but the DA is pushing the case forward and wants to take it to trial? How can the DA win if the alleged victim is going to get on the stand and say that they don't want charges to go forward? In this video, I will be answering those questions. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. Okay, so let's jump right in. Let's say that the alleged victim in a domestic violence case that has actually been filed in court wants the charges dropped, and the case is at the point where it is going to go to trial. The DA is pushing it. The DA does not want to drop it, and it's looking like it probably is going to trial. What happens then? This question is actually based on a comment that someone left on the channel here. Let's say the victim wants to drop all charges towards his partner, but the DA wants to continue pressing charges and take it to trial. My friend is 5'1" and her partner is 5'11" and has a background in martial arts. He weighs over 250 pounds and she weighs 120 pounds. I believe the reason why the DA wants to continue to take her to trial is because she was a former police officer. I don't believe her attorney talked to the DA before going to court, but the victim sent an email to the DA clarifying how he wants to drop all charges, and his reasoning was to take everything away from her, and he provoked her intentionally. Okay, so this is a really common situation where charges have been filed. By the way, if they haven't been yet, you should have an attorney contact the DA and try to get them dropped before court. But if that fails, or you're already past that point, the DA can keep pressing it. And I've had trials like this. I've had trials where the victim is on my client's side. The victim is actually calling me and talking to me and wants nothing more than the charges to be dropped, right? And so whatever they say on the stand is going to be good for the defense and not good for the DA. A lot of people ask, what happens if the alleged victim does not come to trial? If they get subpoenaed, if they don't come to trial, what will happen? Well, whether or not that is helpful depends on how much other evidence there is that the DA will be able to use. What the DA will typically do is they will try to use the victim's statements at the time of the arrest, especially if there was body-worn video. And they will argue that the victim was telling the truth when they first made this report, when they first talked to the cops, but they are lying now. Is there video that the DA will be able to use where you did make a statement saying that abuse did occur? Because if that's the case, it might be better for the defense if you do show up and if you explain, well, I lied then, and this is why. In those cases, it is very important to do two things. Number one, the defense attorney needs to argue to the judge that any interview of the alleged victim is inadmissible as hearsay and whatever other grounds they can come up with. It might or might not be. This is going to be a very fact-intensive analysis. So hearsay is when you use an out-of-court statement, so anything outside of the courtroom, that courtroom or another courtroom, that is offered for the truth of the matter asserted. So you're saying that whatever was said in the video, the reason why you're trying to show it in court is to show that it is true. Now, there are some exceptions to that. One exception is excited utterance. This is something that the DA will try to use a lot. They will try to say that the alleged victim was still under the shock of this whole situation of abuse. And so when they were explaining what happened to the cops, that's not hearsay. That can be brought in because it is an excited utterance. Now, that may or may not fly. Can they prove that there was an abusive situation to begin with so that they can say that you were under the shock of this situation? It's really important that the defense attorney does not treat the video, body-worn video, if there is one, or audio of a 911 call or anything like that, as just one piece of evidence. You have to analyze every statement that was made in that video or in the audio to see if it is hearsay or if there's some other basis to be able to keep it out. Maybe there are some statements made that are not relevant, for example. So the defense attorney should go line by line and see what they can get thrown out. And a lot of defense attorneys don't do this. Why? Because it is time intensive and because it takes a lot of attention to detail in order to do this. And some of them, I think, just don't really think of it. they just think, okay, well, the video will either come in or it won't. That's not true. Each statement has to be treated individually. And what I love doing in this situation, if I can get the judge to agree that even some of the statements are hearsay or are otherwise inadmissible or irrelevant, is telling the judge, okay, well, then those parts of the video should not be able to come in. And so then it's up to the DA to figure out how to edit the video, to make clips of the video, to make sure that they are able to show only the parts of the video that are allowed and not show any of the others. Now, this causes a problem for the DA, like a technical challenge, basically. It depends on how tech savvy they are, how much time they have, and how much support their office provides. But my home county, although I work throughout the state of California on these cases, is Los Angeles, which has a huge DA's office, huge city attorney's office, and this messes them up. They might decide not to use the video at all because they simply do not have the time, the capability, or the resources to edit the video to comply with the court's order regarding what is admissible and what is not. The second thing that is really important in the defense where the victim is changing their story. At first they said, yes, there was abuse. Now they're saying that there was not. And so whatever they said at first was a lie, is they need to have a really good explanation as to why they lied initially. And if the alleged victim is on the side of the defense, they are going to have to sell that to the jury. Of course, defense attorneys can argue that, but you need the victim to actually look the jury in the eyes and sell them on it. And this is not something that the victim should do on their own. The statement that was mentioned in this comment, the victim sent an email to the DA clarifying how he wants to drop all charges, and his reasoning was to take everything away from her and he provoked her intentionally. That's problematic. He provoked her intentionally. That makes it sound like she did commit some kind of domestic violence, but he drove her to it. And the victim driving the defendant to commit domestic violence is not a legal defense. Also, by the victim explaining, especially in writing, to the DA, the reason that they want charges dropped or the reason why they initially accused the defendant, they're tying themselves to that statement. One plausible reason why he might, when the cops come out and they're taking statements, say, she attacked me, would be that he was afraid that otherwise he would be arrested, because usually it is the guy who's arrested. Another explanation that he might give that he didn't tell the police or was misinterpreted would be that he was the initial aggressor, not that he provoked the other party, but that he caused some sort of physical altercation first. But once you give your statement, your side of the story in writing, and you send it to the DA, then if you try to change or add to your story, maybe you forgot something when you were writing that email, you just didn't think of it at the time, and maybe, watching a video like this, you think, oh, yeah, okay, well, I did provoke her, and I also threw something at her. It didn't hit her, but that was one of the ways I provoked her. Okay, well, now maybe her attacking you is actually potentially self-defense, but you didn't include it in the email. And so the DA is going to use that email to show that you are being inconsistent if you try to explain that in court. So although well-meaning, writing a statement out and giving it to the DA, like sort of DIYing this, it's probably not going to work out in your favor. And again, it's on a case-by-case basis. I very much appreciate the person who left this comment, and I'm not saying that the case is necessarily doomed. I think that what she wrote here was paraphrased, and perhaps the actual email is okay, but ideally you have a defense attorney who knows what they're doing, who handles these cases, looking at it, thinking about all the possibilities, thinking about what makes sense, looking at all the evidence and analyzing the victim's statements before you give the DA your side of the story. I hope you found this video helpful. If you do have a domestic violence case in California that you need help with, feel free to give me a call. You can find my number down below. You can also book a consultation directly there. And if you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.